let people
Sir.
continue joining and you can start.
Sir. A very good evening to everyone present here. We have Mr. Mayank Mishra with us. Let me first introduce Mayank Mishra to the forum. Mayank Mishra is a seasoned lawyer with 12 years of experience in managing corporate transactions, strategic investments, deals, negotiations, and corporate litigation with various leading law firms and impact-focused venture capital funds. As the youngest AVP at Caspian Advisor, Mayank has successfully led teams and handled legal and statutory compliances, investments, and exits across 4 different funds of Caspian Group. Over the year, Mayank has developed a comprehensive understanding of the impact sector and startup ecosystem. Academically speaking, Mayank is a gold medalist in law from Hidayatullah National Law University, Raipur, and has attended an executive program in finance from IIM Ahmedabad and IIM Bangalore. He has also secured a PG certificate in management from AIMA New Delhi, and currently he is pursuing LLM in corporate and financial law from Jindal Global Law School. And he has also got an opportunity to Indian School of Business Hyderabad for executive MBA program. I'll hand over the floor to Mayank for taking over this session. Thank you, Mayank. The floor is yours.
Thank you so very much, Anindya, for the elaborate introduction, if I can say so. Thanks a lot for that. Just to understand the group, we have students from which are like 3rd, 4th, 5th year.
Majorly, we have final year students, 10 semester students, and all the students who are interested in administrative law. We also have some guests from outside GD Goenka Institute, and it's a group of all those who are interested in investment and finance sector.
Understood. Great. Okay. So good evening, everyone. I'll present my screen to you, and then we can quickly start the presentation. Just give me a minute. Anindya, I'm unable to present it. It's not allowing me to present.
Let me just check.
Yeah, now I've got that.
Did you get it?
Yes, just a second. Okay. So let me know once you are able to see.
Something has started. Yeah, now we can see Mayank.
Okay.
Perfect. Before Mayank start and I interrupt in between, I'll let everyone know beforehand that by the end of this session, before the last 5-10 minutes, I'll be sharing a feedback form for all of you in the chat box, and all those who will be successfully filling it will automatically get a participation certificate after submission of that feedback form. And the feedback form after sharing will be open only for next 15-20 minutes. After that, we'll log that feedback form for avoiding any kind of misuse. Thank you, Mayank. We can start.
Okay, thank you. Good evening, everyone. So today what we are going to discuss is the investment agreements in the equity space. And I'll be walking you through the 3 key agreements, which are share purchase agreement, share subscription agreement, and shareholders agreement. That's the broad agenda. I try to keep things very simple for you to understand what these agreements are. And how I'm going to take you or walk you through this presentation is, number one, we will understand what financial investment is all about and what all are the different types of financial investments or options available. We will get into the equity investments as to what is equity investment, which is a part of financial investment, and various types of equity investment. Then we will quickly jump into the different types of agreement, which I mentioned at the beginning of the call: SPA, SSA, and SHA. SPA is share purchase agreement, SSA is share subscription agreement, and shareholders agreement. Don't get into the jargon, etc. By the end of this session, you will know that what these agreements stand for and how they are. Then we will quickly move into few key clauses which are there. And the way I have structured this presentation is, if you see serial number 4, serial number 5, and serial number 6 on your screen, serial number 4 are the key clauses which you can use in almost all kinds of agreements, whether it's a service agreement or, for that matter, employment agreement or investment agreement. 5 and 6 are the specific clauses which gets into a particular agreement and gives it a color of a share purchase agreement or shareholders agreement. So while the purpose of this presentation is to walk you through investment agreements, I will also take you through some of the key clauses which you should know and which you should be aware of, so that you can help yourself for drafting any other kind of agreement using some of these clauses. We will have some FAQs in terms of what basic questions I believe you may have on the presentation. And over and above that, if there are any other questions, I'm happy to take that. So this is the plan. We will do it in next 45-50 minutes, and I'll keep the floor open at the end for any questions. In between, if you have any specific question, I'll request you to hold back to that. At the end of the presentation, I'll take all the questions. So let's start with what is financial investment. Now, financial investment, as you can see on your screen, is nothing but an investment where an investor puts in his money in form of an asset to gain financial return in a stipulated period of time. Now, in the entire definition, just read the red highlighted text. So financial investment means an investment where an investor, which is one person, he is putting his money in for certain assets. Now, what are these assets? The list is there. There can be shares, fixed deposit, cryptocurrencies, commodities, gold, land, tangible, intangible asset, anything. So the moment somebody puts in his money in any of the assets, and what is the purpose of this investment? To get financial return in a stipulated period of time. So I can say that I want to buy a house so that this house gives me a security. I have my own house to stay. But at some point in time, if I sell, I should get some return also, which means if I have bought it for 100 rupees, I can sell it for 150 or 200 rupees. The time can be 5 years, 10 years, 20 years, doesn't matter. So long as you are making this kind of investment, it is considered as financial investment. And as you can see on the lower part of your screen, there are a lot of options to make these financial investments. For the purpose of this presentation, what we are going to do is we are going to read or understand financial investment in the shares of the company. So if it is mutual fund, fixed deposit, or any other different kind of investment, I am not going to look into it. I am going to emphasize only on the investment in the shares of a company. And this is the presentation scope. So now let's understand, when we say shares, shares are nothing but equity investments. And you can have equity investment in two forms. Whether you can have equity investment in form of a primary equity investment or secondary equity investment. So as I said, equity investment is nothing but acquiring the shares of the company. So let's assume that there is company, say Reliance Industries. Now, Reliance Industries 10 years back has issued, let's say, 100 shares. Now, if you want to buy any one share of Reliance Industry, how will you buy? These 100 shares are held by different individuals, Mukesh Ambani and others. So you will go to these individuals and say that, hey, I want to buy one share of Reliance Industry because there are total 100 shares. And therefore, please give me one share. They'll say, okay, I'm ready to give you, but please give me money for this. That means a share is already there, which is 100 shares, and you are buying or you are just exchanging the hands of those shares. This is called a secondary transaction, which essentially means that if something is already there, which secondary, you can consider it, while it's not a right way of looking into it, but it's like a second-hand transaction wherein if I have a laptop and I want to sell it, so you can buy it from me, or you can buy a brand new laptop from any retail shop. So if you're buying a brand new laptop from a retail shop, it is considered as primary investment. Likewise, if you buy a brand new shares from a company, which company is issuing, it becomes a primary equity investment. If you buy an existing share, which is like somebody is already holding that share, and if you're buying that particular share, it becomes a secondary equity investment. So for both primary equity investment and secondary equity investment, we have different types of agreements which are required to be drafted. And these kind of agreements which needs to be drafted is what we are going to study. So are you clear about primary and secondary equity investment? If somebody can just say yes or no.
Yes, sir.
Yes, sir. Thank you.
Okay, perfect. So let's understand that for acquiring the shares of the company, what are the three types of agreement? The first agreement is the share purchase agreement. The second agreement is share subscription agreement. And third agreement is the shareholders agreement. Now, share purchase agreement. So if you see in the first and second agreement, share and agreement is common. It's a three-word phrase: share purchase agreement and share subscription agreement. The only thing which is changing is the word which is coming in between, which is purchase and subscription. Now, purchase, you purchase always consider as if it is a second-hand purchase. That means you are going to purchase it from somebody who already has it. So if I have one share of Reliance and you want to buy it, you will give me money and I will give you shares. You don't need to go to Reliance Industry and say that, hey, I want to buy your shares. It doesn't matter because Reliance has given that share to me. I'm giving it to you. And in future, you can give it to third party. Any agreement which deals with flow of shares between the shareholders is called as share purchase agreement, because what you are doing is you are purchasing this agreement. The second is share subscription agreement. Now, if you remember, when you say that Netflix, for example, which most of you must be watching, or Gmail, or a lot of other mailers, you say that subscribe here. It is always written. Subscribe here means you have a direct relationship with the service provider, wherein, for example, if you want to buy a Netflix account, it will say that it won't say login. It will say subscribe here. So you have to give all your details, pay money to Netflix, and then your subscription starts. The same thing happens with the shares as well, wherein you pay money directly to the company and company will issue shares to you. In a public market, it is called as IPO, initial public offering. So you must have read in newspaper that Zomato is going to come up with an IPO. Last week, Paytm said that next year it's going to come with an IPO. In these scenarios, you have to go to the company and purchase their shares directly from the company. Existing shareholders, you don't go to them. And this is what the share subscription agreement is all about. Now, usually share subscription agreement is not applicable in case of a public listed company, because if you are a public listed company, then there are no restriction on transferability of shares, etc. And you don't get into the share subscription agreement. There is a different set of agreements which are required and how you subscribe to the shares of a company. We will not get into it. What we are emphasizing is, in case of a private limited company, how does you subscribe to the shares of the company on what agreement? So consider all these three agreements for private limited company only. The third agreement which you are seeing is a shareholders agreement. So either you have acquired one share from Mayank, which is me, or you have taken one share directly from Reliance Industry. At the end of the day, you become a shareholder. Now the question comes that if you become a shareholder, what rights you will have in the company? Can you say to the company that, hey, please don't do this particular thing? Or if you become a shareholder in, let's say, Reliance Jio, and can you say and go and say that I don't have a good network in my college, so can you put a tower in my college? I am your shareholder. Or can you go to them and say that, no, don't launch 5G. It is bad for health. Juhi Chawla has filed a petition before Delhi High Court. I'm supporting that, so don't launch it. What rights do you have? Can you say that I want to be on a board of a company because I hold one share? So these kind of things, what rights will you get, what liabilities do you have, is actually governed in a third document, which is a shareholders agreement. So now what we will do is that we will get into each of these three agreements and understand what clauses comes into these agreements, and then we will get from there in terms of how to structure it. Any questions so far?
No, sir, thank you.
Okay. So before we get into a specific class of an agreement, which is share purchase agreement, shareholders agreement, or share subscription agreement, let us first understand some very basic agreement. And I would say that this is a bonus slide, which you can use these 8 types of clauses which are there in almost all kinds of agreement. And what all are these 8 clauses or pointers? Number 1 is the title of the agreement and where this agreement was executed. So whether it's a share purchase agreement, rent agreement, lease agreement, you have to have a title of the agreement, which should be very clear. It should also have a date, on what date this agreement is signed. Naturally, the moment you put that it is a rent agreement or a shareholders agreement, the second thing comes in the mind is that who has signed it, which is nothing but the party's name or the details of the party. So this agreement is executed between XYZ and ABC, and on what date, etc. Third is the recitals to the agreement. Now, recital is essentially the background to it. So let's say, because we are talking about investment agreement, the recital can be that Professor Anand wants to buy 10 shares of Reliance Industries Limited. Professor Anand is a resident Indian. Mayank Mishra is also a resident Indian and he holds 10 shares of Reliance. Mr. Anand has approached Mr. Mayank, and Mr. Mayank has agreed that he will sell his shares to Mr. Anand at a price of so and so. So this entire background on the basis of which this discussion happened, at what price, etc., the crux of it, the background of it, goes into the recital to any agreement. So any kind of agreement, whatever you take it, for example, let's say a rent agreement. So it will say that the lessor is the owner of a flat in so and so place. It is a 2 BHK or a 3 BHK flat. The lessee wants to take this flat on a rent, and therefore lessor is entering into this agreement with the lessee to give this flat on the rent or something, or lease. Now this becomes the recital. Once you have established that the title of the agreement, the parties, and the recital, the basis on which this, or the background of this agreement, you enter into definition and interpretation. Definition is nothing but those terms which are used every time, and you use it across the agreement, but instead of saying, so for example, if I say flat, now what does flat means? So flat means a 3 BHK flat which is situated in, let's say, Gurgaon, in so and so apartment, so and so floor, etc., etc. Now every time giving the full description of the flat, if I define flat means this, then it gives certainty to the contract, and therefore we will use definition and interpretation. Again, there can be definition which will be different for every kind of agreement. In an investment agreement, these definition includes what does number of shares means. So instead of saying that every time I want to sell 10 shares, 10 shares, I can say sale shares. Now sale shares means 10 shares. Likewise, instead of saying Mayank or Professor Anand every time, I can say buyer and seller or a shareholder. So this is how we try to define the terms. Then you see XXX in red. These are the key clauses which we will read, and these are the clauses which will differentiate the share purchase agreement with shareholders agreement with a share subscription agreement. And I will skip it for the time being, and because we are going to take it in the next 2 slides. After that, it comes to the indemnity. As you would have read, indemnity is nothing but putting somebody into the original position in case there is a loss suffered by a third party. So for example, let's say I am selling my 10 shares to the buyer, and because buyer has approached me, I am ready to sell my 10 shares to the buyer. For whatever reason, let's say One day before this particular sale, I have gifted all these shares to my son. Now, if that happens, that means on the day of sale, I don't have the title over these shares, but still I have fraudulently given these shares to the buyer. After 5 days, my son get to know that, okay, my father has actually given my shares, which he has gifted to me just one day before, to the buyer. So what he will do is that, or what rather buyer will say is that, please return my money because I have suffered a loss. So on what condition the loss is suffered? How much money do I need to give? If the shares price on the day he has purchased was 100 rupees, but now it has become 1000 rupees. Do I need to give him 1000 rupees or 100 rupees? When will I give it? Will I give it in cash, or is there any other way I can compensate him? So all these clauses gets into the indemnity clause. Again, this indemnity clause is common for all kinds of agreement. Point number 6 becomes the term and termination. What is the term? Term is nothing but a tenor or validity of this agreement. How long this agreement will be valid? Will it be valid for a 1 month, 1 year, or in perpetual? That means throughout the life of the company. What are the grounds for termination? Can I terminate this agreement after signing it, or can I not terminate it, etc.? Governing law and dispute resolution. In case if there is a dispute which comes in, then what will be the governing law? Whether this contract will be governed by laws of India or it will be a private international law. Let's say there are countries across a different jurisdiction or different. Then what is the dispute resolution, in the sense whether we will go to an arbitration tribunal or not? If an arbitration tribunal we are going, whether it will be a sole arbitrator or a 3 arbitrator, who will appoint this arbitrator? So all these clauses comes into governing law and dispute resolution. And last is the miscellaneous clause. We call it as boilerplate clause also, where severability, waiver, specific performance of the contract, who will bear the cost of the lawyers and other expenses. So all those miscellaneous clauses comes into. I will give you this presentation, or I'll give this presentation to Professor Anand, and he can share with you after the session. But please keep this in mind that these are very, very standard provision which will be used in all kinds of investment agreement, and also you can use them in any other form of agreement. Now comes the crux of it. So this slide and the next slide are the two most important slides which will differentiate how an agreement will be structured and how can you call an agreement as a share purchase agreement and share subscription agreement. So the first question which will come to your head is that while the heading says SPA and SSA key clauses, which is share purchase agreement and share subscription agreement. Share purchase agreement is nothing but a second-hand agreement where you are buying shares from an existing shareholder. Share subscription agreement, SSA, is nothing but where you buy shares from the company. So you're talking about two different types of agreement, but the number of clauses which are there are exactly same. Can it happen that you can have the exact same clauses for two different agreements? Well, the heading of the two agreements or all these clauses can remain same, but the way we will structure this clauses, the way we will draft it will be different. So let's go with each of the 7 points and see how these clauses are different and how will we draft it for a share purchase agreement and share subscription agreement. So can somebody help me? I will start with the share purchase agreement in terms of how we are going to draft this agreement. And let's try to make this session little interactive. And others can say that how will they draft the same clause in case of a share subscription agreement. So first is the fundamental terms, which is number of shares. So in a share purchase agreement, I will give the number of shares which I want to purchase. Do you think can we have the same clause in the share subscription agreement also? Anyone?
Yes, sir. We can define the number of shares in that.
Perfect. So
Yes, sir.
both in the share purchase agreement and share subscription agreement, we can have the number of shares. The only difference is in a share purchase agreement, I will be buying these shares from the existing shareholders, from the share subscription agreement, I'll be buying it from the company directly. The second is the consideration. At what price I am going to buy these shares. So if I want to buy 10 shares at 10 rupees each in the share purchase agreement, can I mention the same thing in the share subscription agreement also?
Yes, sir.
Yes, sir. So it's
Yes.
consideration.
Perfect. So the first clause, which is the fundamental clause, how many number of shares you are going to buy, at what price you are going to buy, remains common in both. However, the way you will word it will be different, and I'm not getting into the drafting of this agreement, but broadly just understand how much similarity is there both in the SP and SSA. Now let's get into the representation, warranty, and covenants. Forget the investment agreement. For the time being, just imagine that you are going to a car showroom to buy a car. What are the 2-3 things you will ask for? First of all, you will say that, okay, is this a car which is by Maruti or a Hyundai or any other BMW, Mercedes? You need to check which brand you are buying. Once you have decided that, okay, I'm going to buy a Maruti car, what you will go is that I want to buy a car which is a 6-seater. It should have a good mileage, and these are your requirements. Based on this customer feedback, etc., what Maruti does is that it comes with a brochure, which will say that, okay, I have come up with a car. Now my car will give an average of, let's say, 15 kilometers per liter. My car is also going to run for 1 lakh kilometer without servicing, let's say. This is the best car in the market. This is brand new car which I am giving you. What I'm giving you is actually the Maruti car, and it's not some Hyundai car where I'm putting a Maruti sticker. And there can be like hundreds of covenants and representation and warranties that this car's engine will not fail for next 3 years. If there is any problem which comes in this car, you get this car to me and I will repair it for free. Something like this. If there is a big damage in the car, I will give you a new car. All these things are representation, warranty, and covenants in different forms, and each of these words, representation, warranty, and covenants, have a different connotation or meaning. So for example, representation is nothing but the statement of fact. The fact that there is a car which is manufactured by Maruti. Now this is a representation. Warranty is nothing but a statement which you are giving him and giving in form of a warranty. So for example, this car will run for 1 lakh kilometer without any problem. And there is no requirement for a servicing or changing the tire or changing oil, etc., etc. This is the warranty. If there is any problem, you come to me, I'll replace it for free. Covenant is something that in future, this is how this car will perform, which means that this car, sir, for sure will run for 1 lakh kilometer without any problem. However, I am also telling you that 1 lakh is the warranty which I am giving. Agar 1 lakh kilometer ke andar koi problem hoti hai, you come to me. But trust me, it will run for 2 lakh kilometers also. That is the future statement which you are giving, for which there is no warranty, is a covenant. And I am telling you in a very loose term. Now, how does these 3 words use in our share purchase agreement? And you have to tell me, can we have a similar clauses in our shareholders agreement? So representation is nothing but I am the owner of this particular share of Reliance Industry is the representation which I can make. Can you make a similar representation in a share subscription agreement?
Correct, sir. Owner of the share and the name of the company.
You are right. However, the slight distinction here is that these shares company is issuing, and company is not, in the sense these shares will be issuing for the first time to you. So company will say that I have an authority to issue this share, instead of saying that I am the owner of these shares, because these are coming to you for the first time. The moment I say company owns these shares, that means these shares have become the second-hand share. So the representation will be different from the SPA, where somebody is already a owner, versus the SSA, where company will actually say that I'm issuing you these shares and I have full power to issue it. Warranty can be essentially that there are no cases filed against me which can vitiate or which can nullify this particular transfer. That can be a warranty, because if there is a problem in my title of the share, then there can be the buyer will not buy. So this is the warranty I am giving. Can we have a warranty also in the SSA?
That company will give warranty that they have the authority to subscribe, that
Perfect.
this will not be a fraudulent transaction.
Correct. So the warranty can also come in. Covenant is essentially, it depends upon the fact that covenant can be that if I am selling you these shares, then within X number of days, I will give you the share certificate, or I will record your name in the register of members, etc., etc. Can we have the similar clause in both SPA and SSA? The answer is yes. We can have the similar kind of covenant, which is future obligation. Either the seller can say that if I have sold you these shares, then I will go and tell to the company that I have sold you these shares. I will get your name recorded. If company is selling, company will say that I will do this thing on my own. So covenant can also be there. Now, point number 3 is very interesting. Okay. And this is something which I'm sure you guys would have also done it. Wherein what happens is you go, let's again take an example of car. What you do is that you want to buy a car, you will go with your father or you will go yourself to a showroom. You will like a car and you will say that this is the final car, please keep it ready. And I will come on Sunday morning to pick up this car, and that time I will pay you all the money, everything. So you are signing the document in the sense that you are saying that I will give you, or I'm undertaking to buy this car on a Friday, but I will buy this car only on Sunday. That means between Friday and Sunday, this car will remain with you, but I'm going to take it only on Sunday. Have you experienced similar thing in lot many other places, whether you are buying your, not the small ticket item in the sense jeans, t-shirt, not that, but if you're buying a laptop or you're buying a TV or you're buying few other expensive stuff, you go, you finalize a deal on a particular day, and then maybe on an auspicious day or some next day, or depending upon your convenience, you buy that item. Is that right? Have you
Yes, sir.
experienced?
In most cases.
Yes,
The
sir. Yes,
same,
sir.
the same thing
People buy
happens.
cars.
Correct. So the exact same thing happens in a financial transaction also, wherein you sign a contract, let's say on a Friday evening, and say that I will buy these shares on Monday. This is what we are doing. Just imagine a scenario wherein you have signed the contract on Friday, but Saturday and Sunday, the seller has actually sold his shares to somebody, or is no longer interested to sell you because he thinks that he is cut this deal in a very cheap manner or at a very low price, etc. So to avoid all these uncertainty, I will tell between signing and closing, you please don't do XYZ things. Now just, this is the broad example. Now let's get into the share purchase agreement. So in a share purchase agreement, let's say if I am buying the shares, what will I say? I will say that please do not sell these shares from today until I buy it to any third party. He will say, okay, I'll not sell these shares, but I will pledge these shares. Now, sale and pledge are different. So I'll also say that, no, you cannot pledge or create any kind of encumbrance. So there can be hundreds of things which can come in between signing and closing. The longer the period it is, the more terms and conditions we put in between signing and closing. So this is what we do in the SPA. In the share subscription agreement also, I will tell to the company that you have committed that you will give me 10 shares. That means I will become 10% shareholder of the company. Please do not issue more shares, because what will happen is that you will give me my 10 shares, but just imagine that if there are 10 more shareholders to whom you are going to give 10 shares, then my shareholding from 10% will become 1%, which makes absolutely no sense because I want to buy 10% of the company. So between signing and closing, I'll say that company will not issue any new shares. Or let's say in an example of car, I will say to the dealer that Okay, this is a brand new car. Now dealer on a Saturday, Sunday takes your car for 1,000 kilometer ride because he says that Friday ko aapne bol diya tha kharidenge. That means deal is done. So now before I give it on Monday, let me take this car for a ride. So those kind of conditions which are there, which we believe are very obvious and we should not include in, we have to include it in the financial agreement, because what is obvious for you may or may not be obvious for me. And likewise, what is obvious for me may not be obvious for you. So do you understand what is the conduct between signing and closing, which is Friday and Monday, what all things I have to do?
Yes, sir.
Yes, sir.
Okay. And this can be applicable both for buyer and seller, wherein the seller will say, I am telling it to the seller that please don't sell it to anybody, or I'm selling company that don't issue new shares, etc. From the buyer point of view, it can be that seller will say that I know you have only 100 rupees. So please don't spend this 100 rupees to a third party. Or don't go and do XYZ things with this because you have to give me this 100 rupees on Monday. So those kind of terms and conditions can come in. Now, point number 4 is condition precedent. And point number 6 is condition subsequent. So precedent, what do you mean precedent means? What does precedent means?
Before something
Before.
that's happened previously.
And what is condition subsequent?
That will happen
That happened
afterwards.
post it,
Okay.
after the happening.
And what does completion means?
When you have received the shares.
Perfect. So now 4, 5, and 6, let's take all three together. Or before we take 4, 5, and 6, just hear me out. Number 1, I have said that how many shares I want to buy and at what price. Then I am saying that from whoever I am buying it, he is telling me that he is the correct owner of these shares. These shares are of only Reliance and he's not selling me the shares of Kingfisher or any other bankrupt company. Then he is saying that, okay, fine, we have identified these are the shares. Then I am telling him that between I sign, which is Friday and Monday, don't do XYZ things. This is what we have said. Now on Monday for me to buy, so condition precedent is essentially before I buy what all things you have to do. Which essentially means that in this case, I will say that if I'm again buying a car, I will say that please clean this car thoroughly. Please check whether all the spare parts in this car is there or not. If I have asked for specific accessories to be put in, then do that. Or if I'm buying a laptop, then I'll say that, okay, install a Windows or install various other softwares, install a Microsoft Office and a lot of other things. So those things which I want him to complete before I give him the check or before I pay him the money becomes condition precedent. So the question comes in, what is the difference between signing and closing and condition precedent? See, between signing and closing, I am giving him that please don't do XYZ things. In condition precedent, I am telling him that please do XYZ things. So that's the difference between 3 and 4. So condition precedent is as soon as before I buy, please don't do XYZ things. That's between signing and closing. Condition precedent is please do XYZ things when I buy these shares or before I buy these shares. Point number 5, closing or completion is on the day when I am buying it. For example, on Monday when you are going to buy the car, showroom should give you 2 car keys. Showroom should give you all the car papers, etc. So all these things, he cannot give you car keys on Sunday or Saturday, right? Because if he gives you a car, that means he has delivered you the car key. If he has given you the car keys, that means he has delivered you the car. So that cannot happen. So what he is doing on the day when you are getting the car becomes the completion, because that's the day when you have got it. Now let's take and then condition subsequent. Condition subsequent is essentially that for next 1 year, I will do free servicing for you. Or if you come for anything, I will do that. That becomes a condition subsequent. Now let's take 4, 5, and 6 item number in case of a financial transaction. So before I buy the shares, what all will you do? You have to keep the share certificate. So let's say this person has kept the share certificate in his locker. So he should take out that share certificate. If There are certain consent which he needs to take from his daughter or wife or son or somebody. Please take all those consent, etc. So that becomes a condition precedent. On the closing date, please hand over me the original share certificate. Please hand over me the original shares transfer form. So these are the obligations which I am putting in. Likewise, I have to give him a check, or I have to give him cash, or I have to give him a demand draft or do a RTGS transaction. So all those things has to be written, and those becomes item number 5, which is the closing or completion item. Item number 6 becomes the condition subsequent, which is essentially once you have received the shares, what all will you do? Will you inform to the company? Will you update the register of members? Will you file certain forms with the government of India that I have acquired it? Will you file your income tax return, etc.? So these are the key clauses which comes in. Can we have the similar clauses in the share subscription agreement also, where company is issuing these shares?
Yes, sir.
So how will these clauses work? Can somebody tell me?
Firstly, when you say condition precedent, then the company will say that these are the set of conditions that you need to fulfill before you buy the shares. You need to have a PAN card, you need to have,
Correct.
or etc. You need to be authorized person if you're buying it, or if you're buying it through a company. Then closing or completion is when you receive those shares, when that party receives it, and condition subsequent will be the same. Like filing, like the company already knows about it, but they need to still maintain a register, so they will have to inform or something, some form of that or the other.
Correct.
So I had a doubt in this.
Yes.
Where will I put in if it's preferential share or equity share, and what is the main, like, if you take preferential share, will these agreements will be the same, correct?
Right. So the number one thing which is fundamental terms in term how many shares you are acquiring, what type of shares, whether they are preferential or equity, if they are partly paid or fully paid up shares, all that will come in the fundamental terms. So
Okay.
imagine you are buying a car, you go to a Maruti showroom and there are 5 different models of the car. So first thing what you will do before you ask that what is the mileage, when can I get a delivery, which color do I want, you have to finalize which model you have to do. So likewise, whether it's an equity share or a preferential share gets into the fundamental terms.
Sir, I just wanted to add on to something actually. Like in terms of SSA, when there's conditions precedent, because it's different from the part that it's a subscription basis, correct? So maybe in the precedent conditions, we talk about how per subscription, you're paying before, or there's some mode of payment that is different from SPA, or is that the same thing?
Right. So condition precedent, what happens is, say, the moment you make the payment, you want to receive the same item immediately. So condition precedent in case of a subscription agreement can be, for example, passing of board resolution. So company should pass a board resolution to issue these shares to me. Company, if for example, let's say there are various issues in the company in the sense that company don't have a managing director. So I'm putting 100 crore into a company, but I want a managing director to be there. So I can say that unless company appoints a managing director, I will not pay to this company, or I'll not subscribe to the shares. So there can be various types of condition precedent which can come in, and all these condition precedents are actually, you find it as part of your due diligence. I'm just taking a 2-minute detour here. Due diligence is nothing but doing a health checkup of a company as to what all problems are there in this particular company. So when you do a legal due diligence on the company, you analyze the company from left, right, and center, all kinds of laws, what are applicable to it. And you say that these are the 5 issues which are there in the company, or 10 issues. Unless these issues are resolved, I am not going to invest in the company, or it is not advisable to invest in the company. Then company will make sure that all those issues are rectified or cured, and then you invest. So all those terms can come in form of a condition precedent.
Thank you, sir.
Okay. Last is the indemnity. So I think we have already discussed indemnity in point number 5. Again, indemnity in the SPA and the share subscription agreement can be completely different. In a share purchase agreement, you will take indemnity from the seller because he's the owner of the share. In a share subscription agreement, because the company is issuing these shares for the first time, company will give you indemnity. And depending upon whether there is a tax implication, etc., you take various other kinds of indemnity. So these are the broad clauses which gets into a SPA and SHA. These are just headings. What gets into these clauses, I have just given you a very tip of the iceberg. And obviously, after point number 4, where you see XXX in red, that's where these clauses fits in after definition and interpretation, and before indemnity, because point number 7 is indemnity. So I tried to have a continuous thing here. This is what the construct of SPA and SHA is there. So now just imagine that you have acquired these shares now. Now the question comes in, which we ask, that can you go and say that now I want to sit on the board of the company? Or from tomorrow onwards, because I am a shareholder, all the contracts which this company signs has to have my signature. Or I will change the managing director, CFO, and everyone, or whoever is an employee of the company should come and report to me. Can I ask all those things? The question is, you can, you cannot. And who will determine you can do this or not is the shareholders agreement, or SHA. So imagine like this: before buying, there is a different relationship. After buying, there is a different relationship. Before you buy or subscribe to the shares, there is a share purchase or a share subscription agreement. The moment you have acquired the shares, the shareholders agreement come in. So SHA is nothing but shareholders. Holder means somebody who holds these shares. And when can you hold it? Only when you acquire the share or you have purchased the share from the company or from a third party. So shareholders agreement, what all are the key clauses? Now understand this thing, that you have already acquired the shares from somebody, but others should also know. So all the shareholders of the company signs an agreement which is called as shareholders agreement. The first thing is the shareholding pattern. So far what you are doing is you are saying that I hold 10 shares in the company or 5 shares in the company. Good, it is just a number. But in terms of percentage, you should also know what is the shareholding percentage, who hold how much shares in the company. Can somebody tell me why is it important to know what percentage of shares you hold in the company?
Yes, sir. So that then you know then you have the authority if you have more than X percentage of shares,
Correct.
and you don't base the, as you can increase the number of shares later on, so you don't base these holder agreements on the basis of number of shares, but do it on the percentage wise, so that even when you raise new shares later on, the percentage still defines what the agreement is.
Correct. So the short answer is essentially the resolution, whether if tomorrow there is a resolution which needs to be passed, if it's an ordinary resolution or special resolution, how much can I vote? So for example, if I hold 10% of the company, technically I cannot block anything. But if I hold, let's say 50% of the company, all ordinary resolution will require my consent, because company requires minimum 51% or 50.01% approval, which is the majority or the simple majority, or in case of a special resolution, more than 75% approval. So depending upon how much shares I hold in the company, I will know that how much right do I have in the company. The same thing, depending upon your shareholding comes the governance, whether I get a board seat or not. So if I'm just a 10% shareholder versus a 50% shareholder in a company, I can say that I want to have a board seat. In a board of directors of the company, at least one of my persons should sit. I can say that if company is going to start a new line of business, it will require my compulsory permission. Or if company is going to borrow more than 10 crore rupees in any financial year, it will require my approval. Or if company is venturing out into a new line of business, it will require my approval. So all these kind of things gets into the governance matter. So in the shareholders agreement, because you are already a shareholder, depending upon how much shares you hold in the company, you will negotiate clause 2, which is governance matter, in terms of whether you will get board seat or not, what kind of shareholders right will you have, where you will vote, how will you vote, and all these items. The third clause becomes the restriction on transfer of shares. One of the key feature of a private and limited company, can you tell me what is the key distinction between a private and limited company? Private and public limited company, sorry.
The liability.
It bases upon the transferability of shares.
Right.
Whom they invite in terms of shareholders.
Correct.
A public limited company usually gives they usually give out newspaper ads also when they're inviting applications from shareholders. In terms of liability, in terms of what kind of percentage of shares is there in a private versus a public limited company.
Public listing and private listing.
Perfect. So in all these things, at least for the purpose of agreement, what is important is the free transferability of shares. In a public company, shares are freely transferable. In private company, shares are not freely transferable. There are certain restrictions on transferability of shares. So what kind of restrictions are it? For example, you cannot sell your shares to a competitor, or you cannot sell your shares to a someone who is already an existing shareholder of the company, because if you do that, that existing shareholder will become a majority shareholder. So let's say I am a promoter of a company and I hold 40% of the company. There are two more shareholders who hold 30% each. So technically I hold 40%, which is certainly not 50%. That means I'm not the majority, but between the three, I'm still the largest shareholder. Now just imagine that one shareholder who holds 30% transfer his shares to another shareholder who holds 30%. That means that shareholder who is acquired becomes a 60% shareholder. He comes to the majority, and I am a majority currently at 40% because there are two other shareholders at 30% each. I become a minority, which I don't like. So what I will do is, when I am giving in share purchase or share subscription agreement, when I'm giving it, I will also sign a shareholders agreement, and I will tell them that please make sure that you don't sell your 30% share to other person. Now it's a different matter whether somebody will accept to this kind of restriction or not, but assuming it's a private limited company and I can put in certain restriction on transferability of shares, I can very well put various transferability of shares. I can say that you cannot sell shares to a competitor, or for next 5 years, you cannot sell your shares to anybody. So these restrictions become very important because again, these restrictions actually govern the governance, which is point number 2. What shareholding you will have, point number 1, what kind of board seat, etc. Then comes the information right. So fine, I am a 30%, 40% shareholder of the company.
And if I may ask a question,
Yes.
whether all these conditions that we are discussing as of now for private companies, all these are part of ROFR clause of the of a private company, or ROFR clause, right of first refusal, is only sub part of one of major clause of AOA of a company?
Okay, so that's an excellent question, Professor. I mean, ROFR, which is right of first refusal, or ROFO, which is right of first offer, comes under the restriction on transferability of shares, and it becomes a negotiated clause. And you also incorporate the same clause in the articles of association of the company. So to answer your question, both the clauses ROFR or ROFO are restriction on transferability of shares and will form part of the shareholders agreement depending upon how you have negotiated it.
Thank you.
Okay. So then, depending upon the restriction of transferability of shares, we can also ask for certain information rights that this company on a yearly basis, or let's say on a monthly basis, will give me XYZ details. On a quarterly basis, I should get little more details. So this becomes the information right. Then comes the exit right, in terms of when can I exit from this company, whether company will do an IPO or will do a buyback of my shares. If promoter is selling, can I sell my shares along with promoter? At what price can I sell it? All these clauses, because at the end of the day, and the first slide which we read was financial agreements are not, or what is financial investment? Financial investment is nothing but you are putting in money in an asset which is share in this cost for a future gain. So in future you want to sell it. So unless you have an exit right in terms of how will you exit, sell your shares, it gets very difficult for you to negotiate a good SHA. So exit right becomes most important, because unless you sell, which is exit from the company, you will not make the money. So this clause becomes very important. Point number 6 is the event of default clause, which is nothing but in case if there is a default in the agreement, if promoter for whatever reason says, so let's say there is a restriction on transferability of share, there is a ROFR clause which is there. Now this ROFR or ROFR clause, for whatever reason, one shareholder is just not accepting. He's saying that instead of giving you a ROFR notice, I will directly go and sell this share in the market or to any third party. What happens in that scenario? Whether company is bound to record the transfer of shares or not? Can company reject the transfer of shares? What all other conditions are there? All these conditions comes in the event of default clause, that what all are the event of default and what are the consequences of event of default also. And the last clause, it's continuing obligation, which is more like an enabling clause wherein it says that it will be good to do XYZ thing over a period of 6 months, 1 year. It's more like a, now I have become a shareholder, so company should do XYZ thing over a period of next 5 years. Let's say company should start adopting electronic policy, wherein everything what we are doing in paper should now become electronic, or company should have XYZ other milestones which needs to be met. So these are the continuing obligations which we will put in the shareholders agreement. Any questions on the shareholders agreement?
No, sir.
Sir,
Thank
I
you.
have a doubt. So basically,
Yes.
in the cases of subscription of a DVR, so DVRs are given in the shareholding pattern or the governance and shareholding rights clause.
So DVR is differential voting rights, you are saying, right?
Yes, sir. Yes, sir.
Yes. So differential voting rights can come in two form, depends upon which class of shares you are acquiring. So I'll go to the previous slide, where in the fundamental terms, how many shares you are acquiring and which class, whether preference, equity, if it is equity or preference, then whether you will have DVR or not, will come in the SPA or SHA. And then in point number 1, which is the shareholding pattern, you have to specifically say that these shares don't have a right or will have a special right or what. So, and based on that, we will have the governance structure on board and shareholders right. So it will come both in the SPA or SHA and also on the shareholders agreement as to how will you exercise those rights.
Yeah, sir. Got it. Thank you, sir.
Yeah. Any other question?
Sir, if I
Yes.
may ask, are there any sort of provisions in terms of dilution rights or anti-dilution rights for both of these agreements?
Yes, there will be in the shareholders agreement, there will be a clause on dilution, and dilution is a very not a very difficult concept, but purposefully I have not included it. But since you have asked, I will tell you. Let's say, okay, so let's put it like this. You go to a shop to buy a laptop, and shopkeeper says that this laptop is for 1 lakh rupees. You go, okay, fine. I don't know much about it. I will go and buy this laptop for 1 lakh rupees. Next day, your batchmate comes and says that, hey, I got an exact same laptop from the same shop. So you will say, oh, exciting, good, good, good. And then you ask that, okay, what is the price of your laptop? He says, I bought it for 50,000 rupees. You will feel that I got cheated because this person sold me this exact same laptop yesterday at 1 lakh rupees, and today he is selling the same thing for 50,000 rupees. So what will you do? Can you tell me what will you do in such a scenario?
Maybe I'd go back to him and ask him why he sold less for somebody else and ask
Okay.
him if he could give me any sort of rebate or refund.
Okay. So what happens is In case of a company also, you will do the same thing, wherein you will go to a company and say that, okay, today you have sold shares, one share to me, and anti-dilution work only in the share subscription agreement, or in case where there is a primary company is issuing you the shares. So company today issues shares at 1 lakh rupee, and tomorrow company issues the same share at 50,000 rupees. Now you go to a company and ask him, company says, or this laptop person or the shopkeeper says that, sorry ma'am, मैंने तो आपको 1 लाख रुपए में बेच दिया, now what can I do? I cannot return you the money. What will you do? And you cannot file a case also. What will you do?
Maybe I'll ask him to give me something else to make good of the 50,000.
Right.
Give me some other product, or like, let's say something that accompanies this, some speakers or something as an activity to this.
Correct. So in this case, let's assume that this shopkeeper sells only laptop. What will you do?
Maybe
There's
I'll ask him
nothing
to
else.
give me another
You will
laptop.
take another laptop for that
Another laptop.
50,000 rupees.
Correct. And it sets off and you are also happy.
Yes.
The same thing happens in an anti-dilution, wherein you go to a company is selling only shares. Company has sold you share for 1 lakh rupee, you got one share. 2 days later, you got to know that this company has sold shares at 50,000 rupees. You go to the company and say that, hey, you have sold me for 1 lakh rupee. I have this clause in the shareholders agreement which says that in case in future you sell any shares at a price lower than the price at which you have sold me, you have to give me extra number of shares so that my cost of acquisition and the new person who is acquiring the shares, the cost of acquisition becomes the same.
Okay.
This is nothing but an anti-dilution, a fancy term to what you will do with your common sense. We try to put it in an anti-dilution clause. Obviously, this clause, I have oversimplified it for this particular class. There is a weighted average and a lot of math gets into at what price you will get it, why company has done it. So no need to get into that unless you are in profession. But as a student, just imagine the laptop scenario which I have given you. And this is the classic case of an anti-dilution clause kick in. And you can put it in the shareholders agreement.
Thank you.
Any other question on SHA or the share subscription agreement?
So there's one more, but I think I'll ask at the end of the session otherwise.
Okay. So I'll quickly go to the last slide, and after this we can have discussion. I've already taken 5 minutes more, but few basic questions are there any other alternate name for SPA, SSA, SHA? It's just like I study in university, I study in law school, I study in college. All the terms are going to take you to the same place, more or less. Obviously, there are certain differences between college, university, deemed university, etc. But the fact is that you have graduated from class 12th, and now you are in an integrated program by whatever place you call it, class, university, college, etc., etc. So share purchase agreement, what can be other name for share purchase agreement? Do you think
purchase agreements?
No, so you are purchasing it. It's one part of it. Somebody is transferring also. So can I call it as a share transfer agreement?
Yeah, fair enough.
Fair enough. So depending upon whose side you are drafting it, whether you are drafting it for the purchaser or the seller, you can call it as a share purchase or a share transfer agreement. Share subscription agreement. Can there be a different name? At the end of the day, you are making a
IPO agreement.
Well, IPO usually happens in a public company, and you don't get into an agreement for that. You have a DRHP, which is draft red herring prospectus, or RHP. So I'll not call it as an IPO agreement, but I can call it, or people call it as an investment agreement, because what you're doing is nothing but you are investing money into the company. So you can say an investment agreement. And shareholders agreement, by and large, it is called as securities holder agreement or shareholders agreement only. So you can call it securities purchase agreement, securities transfer agreement, share transfer agreement, SSA investment agreement, you can call it, or shareholders agreement, you call it as a securities holder agreement. More or less, SPA, SSA, and SHA is 90% time. This is how you will call it. The way we say that we are in a law school or a university, hardly anybody says that I go to a college, etc. So that's how it is. Is it compulsory to have these investment agreements in question number 2 in all kinds of investment? The answer is no. Under Companies Act, you don't need these 3 agreements. However, this is an added protection. It becomes a contract, and contract is not governed under Companies Act. It's a separate legislation altogether. So these are contracts which are good to have, but there is no legal requirement to have these agreements under the Companies Act. Is that clear?
Yes, sir.
Now the third question, which is the most important, third and fourth question. As a fresher, are you going to go and start negotiating these agreements right from day one? Or what is expected from you when it comes to these agreements? See, once you are graduate, if you get this agreement at the first place, first thing is expected from you is to understand why this agreement is. Is it a share purchase agreement or a shareholders agreement or a share subscription agreement? See the clauses which we have discussed in this class. Are these clauses there or not? If the clause is not there, you need to tell to your senior that this clause is not there. Ask him why this clause is worded in a particular manner. So ROFR clause or a ROFO clause or any other restriction on transferability of shares, how these clauses are worded, why there is no restriction on transferability of shares. So long as you are able to identify these key clauses, how they are worded, as a first year associate, your work is sorted. And frankly, this is what is expected from you as a first year associate once you get into a law firm, that you are able to understand these agreements, pick key clauses from these agreements, and then put it before your senior, and then he will take it forward from there. If you're too lucky and you're extremely smart, then certainly you can actually draft some of these clauses. But usually that happens after 6 or 8 months once you are into the profession, not in the first 6 months of your job. So these are the few FAQs in terms of what you are expected, whether these agreements are legally required or not. I will rest here. If you have any questions or you want to discuss any specific item, or as part of your internship you have come across a particular problem, I'm happy to take that.
Yes, sir, if I could ask, I had 2 questions.
Yes.
First one was, we're constantly talking about equity and preference shares, but recently the concept of hybrid shares and hybrid securities is on the rise, correct? So
Correct.
are they also covered under these share agreements, or is it just equity and preference shares?
So can you give me an example of a hybrid security when you say?
CCDs, convertible debentures, bonds.
Correct. So what happens is you need to get into a CCD, for example. Now CCD, so long as they are compulsory convertible debentures, which means they are a debt instrument. So long as they are a debt instrument, typically we don't call them as a share and we don't include them here. So in all the 3 financial agreement, we call it as a share subscription agreement, share purchase agreement, and shareholders agreement. Now in CCD, nowhere share word is coming. So I would keep CCD out of it. There is a CCD subscription agreement can be there, which is an altogether different agreement, and it is in nature of debt. So to answer your query, no, I will not include CCD or hybrid instrument in this 3 agreements.
Okay, sir. Another one was, usually like when you spoke to me about the example of the laptop owner, correct? And you said that the option of suing was not there. But for the sake of the example. Now that got me thinking, usually you don't see cases very often where shareholders are suing the company or something like that is happening. So are there any sorts of rights, legal rights as protection for both investors and the person issuing the shares, which that ensures that somebody is not moving out, like somebody is still logged into that agreement, or
Correct.
somebody is still that the interest of a particular shareholder is protected? Because normally when we study shares, even as early as in 12th 11th and 12th grade, we always discuss some rights as protection that is given to a shareholder in certain situations. So is there anything in these agreements also?
Right. So what you have to look at here is the point number 5, which is indemnity. So you can always ask for an indemnity if there are any breach of the agreement. Indemnity can be from the seller or from the company, depending upon which agreement you are getting into. The second thing is you can always go to court. Nobody is stopping you to go to court. In a laptop example, I've given you I have closed that option just to put the point that anti-dilution, how will it work? Because the first answer as a lawyer you will say is that he has cheated me, sold 50,000 ka laptop for 1 lakh rupees, so I'll go to court and sue him. I didn't want to hear that answer. That's why I changed the question and closed your options.
Yes.
But you can go to court. You can also invoke arbitration. You can seek anti-dilution. So depending upon what. So for example, if there is a fraud by the company, they have said that this company. So let's say in the same laptop example, this 1 lakh rupee of laptop which he has sold, he has sold another laptop of 50,000 rupees to your friend, and third day you got to know that this laptop don't function at all. So in this case, you have lost entire 1 lakh rupee. Your friend has lost her entire 50,000 rupees. So you have no option but to go and sue this person or take your refund. But if laptop is functioning, everything is good, then you can say that, okay, give me a second laptop. So you have all kinds of reliefs available under law, depending upon what agreement it is. And you can very well go to court.
Okay, sir. Thank you.
Yeah. Any other question?
I think with this we have come to an end to this session. Do we have any other question from anyone? Okay, I think there is none. So with this, I would like to thank my dear friend Mayank, who agreed on a very short notice to deliver a practical lecture on drafting of these agreements. These agreements, with the kind of response we are seeing from our students, we can understand how interactive and how informative it was. I thank you, Mayank, for being the guest, and let's hope we meet each other physically in the campus when things settle down. And we would love, the GD Goenka's family would love to have you as a guest, as a teacher over there, to teach us more about the practicalities and the in and outs of these agreements. And I would also like to thank all my senior colleagues and my friends at School of Law and outside, all the students, for coming here and learning from this session. I hope it was a session worth for everyone. Another thing, I'm just about to, I have shared the link with you all in the chat box. Please fill that form. The link will be active only till 7:30, that is for 15 minutes. And you can find your certificates maybe in the inbox or maybe in the spam box. Thank you all. Thank you, Mayank.
Sure. Thank you. Thank you very much. And please share this presentation. And thanks a lot, Anand, for this opportunity.
Absolutely, man. It was a wonderful interaction.
Yeah. If any student has any question specifically, feel free to reach out to me. I'll be more than happy. Professor Anand has my email ID. I'll be more than happy to help you, not just when you are a student, but in professional life as well. So all the very best, and have a great future ahead. Thank you.
Thank you so much, sir.
Thank you.
Thank you.
Thank you, sir. And the session is on for next 15 minutes. So all of you who are trying to fill this form, go to the link, fill the form, and get the certificates, right? Because I'll stop this session at 7:30, and then in that case, no one will be able to fill that form and get the certificate. And please be very careful when you are filling the form, because once you have entered your details, it will appear in the certificate as it is. So, and there won't be a second opportunity for rectifying these certificates. Thank you very much. Thank you, sir.